Well, welcome. I'm happy that everyone who's here did turn out today. I'm Paul Atkinson. I'm the Public Legal Education Coordinator at the Center for Constitutional Studies, and Pat Parody sends along her regrets that she wasn't able to attend today. Pat's normally here. I feel very honored, quite frankly, to present Colton Fehr. I've been reading some of his bio, and I've also been looking at a number of his publications. And the topic today, as you know, is Section 7 of the Charter of Rights and Freedoms, which is a very fascinating, but I think on the surface of it, poorly understood. It's a lot of words that don't necessarily convey meaning in the same way as, you know, you have a right to reasonable bail, or, you know, you have a right not to be secure from unreasonable search and seizure. You know, those are pretty straightforward concepts, but the principles of fundamental justice, as Colton is very well prepared to discuss, are quite a bit more complicated, and I think you'll find his talk very interesting. Colton's educational background, Colton has a couple of degrees from the University of Saskatchewan. I think he's a Saskatchewan native, and he has degrees in political science and also some Russian, I believe. Yes. So if you have questions in Russian, Colton may be able to feel a little. No. Da? No. That's all I got. And Colton then did his master's degree. He's also got a law degree from the University of Saskatchewan as well. Colton did a master's degree at the University of Toronto, where he studied under Kent Roach. And Colton's thesis at the University of Toronto is actually one that engaged Section 7. And it dealt with a couple of very interesting defenses, and whether the constitutional or the defenses of necessity and duress should be constitutionalized. And it's a fascinating issue, and it's one that certainly engages the whole issue of Section 7. Colton also has a couple of fairly recent published articles that also deal with issues around Section 7. One of them is Instrumental Rationality and General Deterrence, which was just recently published by the Alberta Law Review. And I was telling Colton earlier that this is a topic that definitely fascinates me, because for the last 30 years, I've been teaching my students in my criminal procedure courses that general deterrence just doesn't work, and that's basically the premise on which Colton's paper was largely based, so I was very happy to see that. And another very recent article, Consent in the Constitution, also addresses Section 7 of the Charter, and that's another one of Colton's. It's published in the Manitoba Law Journal, excuse me. Before I let Colton start, I mean, he's obviously very well attuned and very well qualified to speak on this topic. He's also a bass player who's played in an interesting band called Autopilot. And if you go on YouTube, you can find a number of that band's performances on YouTube with Colton playing bass. So without further ado, Colton Fehr.
Thank you very much. Thanks again, Paul. That's very nice of you. My lecture today is entitled The Principles of Fundamental Justice. What are they anyway? And this term comes from Section 7 of the Charter, and Section 7 provides that everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except for in accordance with the principles of fundamental justice. So the Supreme Court of Canada has interpreted this section as requiring that the applicants prove two things. First, that the law engages their life, liberty, or security of the person interests, and second, that the law is inconsistent with the principle of fundamental justice. Now, Section 7 is a bit oddly worded, as I assume many of you have picked up on by now. A plain reading of Section 7 suggests that the state action must put a citizen's life, liberty, or security of the person in jeopardy. However, the second use of the conjunction and, let's just take a look really quickly. So here's the first use, and there's the second use of the conjunction and. All right, this potentially could be read as providing two independent rights. The first being a right to life, liberty, and security of the person in and of itself, and then a right not to be deprived thereof except for in accordance with the principles of fundamental justice. But the Supreme Court of Canada has yet to find that there is a freestanding right to life, liberty, and security of the person. But they have also stated that they have not explicitly ruled that out. And the court will probably revisit that at some point in the future, but so far they have not. So lower courts, though, have recently been litigating this issue considering whether there is a right to housing in Section 7 of the Charter. So for those of you who attend these lectures regularly, you'll have heard Professor Anna Lund, speak on that issue. But as of yet, the dominant interpretation is in fact that this is not a two-right section, it's a one-right section. So you must prove first that there is a right, that your right to life, liberty, or security of the person has been engaged, and if it has, and only if it has, are you able to ask whether or not that deprivation of life, liberty, or security of the person is in fact inconsistent with the principle of fundamental justice. Okay, so the requirements to qualify as a principle of fundamental justice. So before discussing the content of the principles of fundamental justice, I should at least speak a little bit about these threshold interests, life, liberty, and security of the person. So given that the criminal law, or with the life interest, given that the criminal law has not attempted to implement the death penalty during the life of the Charter of Rights and Freedoms, we've instead seen the meaning of the term life litigated heavily in the context of threats to life. So this raises the question of what degree of threat is in fact necessary to engage the life interest. And the case law is still developing, but a few examples are quite illustrative. So the first comes from a case called PHS, pardon me. And that case, many of you will recognize, it had to do with shutting down a safe injection site in downtown east side Vancouver. And the Supreme Court of Canada determined that the state action that effectively resulted in the safe injection site being shut down, in fact, endangered the people that use that site's lives, because now they're much more likely to use drugs in a much more dangerous way. The safe injection site empirically was proven to save lives, so that engaged the life interest. So in the assisted dying case, known as Carter v. Canada, which I will talk about in much greater detail today, the state's prohibition on assisted suicide was also found to cause many people with debilitating illnesses to take their own lives prematurely out of fear that they would not be able to do so when the suffering became intolerable. So in the Carter case, that was enough to engage the life interest. And several lower courts have found that government laws that might threaten a person's survival engage the life interest. So for instance, prohibitions on panhandling, or prohibition on erecting a temporary overhead shelter in a public place where there are inadequate homeless shelters has been found to engage the life interests. Turning to liberty, so in a narrow sense, liberty means any threat by the state to detain or imprison another person. However, in a broader sense, liberty could incorporate any state limit on action. And so, for instance, we might borrow from the Enlightenment philosopher John Stuart Mill and define liberty as the right to pursue one's own conception of the good in one's own way, so long as harm is not occasioned to another person. But there are two main problems with reading liberty this broadly. The first is an interpretive problem. So liberty in this broader sense would make other liberties in the Charter, so for instance, take Section 2 of the Charter, provides the right to freedom of religion, freedom of association, these types of things, and freedom of speech. It would make those liberties somewhat redundant. To give Section 7 and the liberty interest its own conceptual space, it was necessary to read it in a way that didn't overlap with other rights protections in the Charter. But second, this broader reading arguably would trivialize Charter protections. So if every single act must be consistent with the principles of fundamental justice, then we might expect a fairly significant floodgate of litigation that would overwhelm the courts. And it would also water down our talk about rights if everything had to be consistent with the principle of fundamental justice. So as a result of those 2 points, the Supreme Court has adopted a rather narrow reading of liberty in a case called the Queen and Edward Books. So first, they determined that liberty is engaged where a law even threatens to imprison or detain someone. As a result, so every criminal offense in the criminal code would engage the liberty interest. It will typically threaten jail or at least a probation order. but also laws that increase the severity of the deprivation of liberty might engage the liberty interest. So you might think about transferring someone from a low to a high security prison. That sort of thing engages your liberty interest as well, because the seriousness of the deprivation is increased. But the court has also found that liberty is engaged in limited circumstances out of police arrest or detention, where a decision is of fundamental importance to an individual's human dignity interests. For instance, we might look at Justice Wilson's reasons in the abortion case known as the Queen and Morgentaler. It's quite likely today that that decision was relitigated, that the right to have an abortion will be found to be a decision of fundamental personal importance. With respect to the Carter case, again, the euthanasia case, choosing when and how to die has been determined by the Supreme Court of Canada to be of fundamental personal importance to one's dignity and autonomy interests. An example of a failed argument to engage the liberty interest under this second branch came from the case called the Queen and Mammal Levine, where the Supreme Court concluded, much to many people's disappointments, that in fact smoking marijuana is not of fundamental personal importance, it is in fact a lifestyle choice. Turning to the third interest, security of the person, the Supreme Court has determined that this interest is engaged by deprivations of both bodily and psychological integrity. So use of force on a person qualifies as an obvious threat to bodily integrity. On the other hand, psychological integrity may be engaged in a variety of ways, and the Supreme Court's decision in Carter in Canada is probably the most explicit on this. So the court concluded in that case that requiring someone to endure suffering due to an irremediable medical condition causes adequate psychological tension to engage the security of the person interest. All right. Turning then to the requirements to qualify as a principle of fundamental justice. So on its face, this phrase, as Paul pointed out, is extraordinarily open-ended, and it admits of many possible interpretations. And the court has concluded that the principles of fundamental justice are found in the basic tenets of our legal system, and they derive primarily from our understanding of two things: the rule of law and human rights theory. So obviously the literature on the rule of law and human rights would fill this room, if not the next room over, so I don't want to speak about that in any detail, we just simply don't have any time. But what the court has done is distill this general summary of the principles of fundamental justice into a three-part test. Okay? So in order for something to qualify as a principle of fundamental justice, it must first be a legal... Pardon me? Am I loud enough that everyone can hear me?
Not really.
No, it fell off
Try
your...
the connection at the batteries. We can hear something moving from the actual box, but we can't hear you.
Interesting.
It fell down, that's why.
Yeah, my amp's broken. Is that better?
Yes.
Oh,
It fell down.
Alright, sorry about that. So, coming back to the principles of fundamental justice, the court has determined is required in order to prove that a principle, in fact, qualifies as a principle of fundamental justice. The first thing is that it's a legal principle. So this generally means that any principle of fundamental justice will be taken from the common law, from the statute, or some principle of international law. And the main idea here is that we're trying to exclude any principles that might qualify only as public policy. We want the principles to be strict legal principles. And the second, and by far the most important requirement, is that there's societal consensus that the principle is fundamental to the way in which the legal system ought fairly to operate. And importantly, a societal consensus does not equate with majority rule. So such a standard would be unreasonable for two reasons. First, courts are quite frankly are incapable of gathering such empirical evidence to determine if there is adequate consensus from a democratic perspective. Second, it would be contrary to the purpose of a Bill of Rights, such as the Charter, which is to protect against unjust majoritarian tendencies. So why would we rely on those same majoritarian tendencies in determining what is in fact the principle of fundamental justice? And then finally, the last standard is that the principle must be sufficiently precise to yield a manageable standard. So this requirement ensures that the public, legislature, and other courts and tribunals can understand how a law might run afoul of the principle at issue. So the court has concluded that, quote, vague considerations of what our society deems to be ethical or moral are not adequately precise to qualify as a principle of fundamental justice. Okay. Turning then to the scope of fundamental justice, it was questionable at the time of Section 7's adoption whether the principles of fundamental justice were supposed to be limited to procedural protections or also included substantive protections. So the difference between a procedural and a substantive protection is somewhat murky, but it may be roughly thought of as follows. Substantive principles govern how members of society are to behave. Right? They thus delimit the scope of criminal and other prohibitions. Procedural principles, on the other hand, refers to the procedure for making, administering, and enforcing the substantive law. So in the in R.E.B.C. Motor Vehicle Act, the Supreme Court concluded that Section 7 also protected substantive principles of fundamental justice. And it did so for a number of unique reasons. And I'll just review the first one because it's probably the most important. Frankly, there's a word or a phrase that we can use that specifically connotes that we only want to protect procedural protections. And that term is known as natural justice. So if Parliament wanted to limit the scope of Section 7 to only procedural protections, it could have used the word natural justice. It didn't. Therefore, this was open to interpretation. And based on the fact that the legislature really wasn't all that clear as to whether or not this was supposed to be limited to procedural protections only, the court thought that it was okay for them to interpret fundamental justice in a broad and defendant-friendly sort of manner. Okay. Turning to the procedural principles, I'll say I'm not going to speak very much to these principles. They are by far the more decided principles and less controversial principles of fundamental justice. So what I will say, though, is that the procedural principles protect or require that a tribunal which adjudicates upon a person's rights must act fairly, in good faith, without bias, and in a judicial temper, and must give to him or her the opportunity to adequately state his or her case. So this leads to a variety of fairly basic rights, including disclosure, the right to be heard, the right to read and challenge evidence, and the right to an unbiased sort of decision making. Turning though to the substantive principles of fundamental justice, again, these have to do they question the fairness of a law restricting how an individual may behave. And there are two main categories that the Supreme Court has developed over the last 35 or so years. And these categories include the principles of what the court has called instrumental rationality, and then a second category of what I call principles of moral philosophy. So the principles of instrumental rationality consider whether a law's means are suitable to its ends. So they're directed at two primary crimes. So laws that have effects which are disconnected from the law's purpose, and then second, laws that achieve their purpose, but do so in a manner that has effects that are totally out of sync with that purpose. Okay? So I'll give you three examples. These are instrumental rationalities encompassed by these three principles. The first is arbitrariness. So say that a law says it does X, but in reality, all it does is Y. The law is completely divorced from its objective. That law operates in an arbitrary manner. Or say that the law says it does X, but there's zero empirical evidence to show that it actually can achieve that goal. That law would also be considered an arbitrary law. The second, and by far the most popular of the instrumental rationality principles, is the principle of override. Now this principle admits that a law is connected to its objective in most instances. However, in some readily definable instances, the law is not connected to its objective. Okay? And finally, the principle of gross disproportionality. This principle states that even if a law is connected to its objective in all instances, it might still have effects that are grossly disproportionate when compared to the importance of the objective of the law. So these principles have been used quite a bit lately. The Supreme Court of Canada in the Carter case has said, in fact, that they prefer these instrumental rationality principles to principles of moral philosophy. And I want to take you through two cases that use these principles lately to illustrate how they have affected some of our criminal laws. So the first is the Canada and Bedford case. So I want to give a bit of historical background as to why this case is so important. And we have to go back to 1990, where Parliament sent what is known as a reference question to the Supreme Court of Canada, asking whether three main provisions regulating sex work were constitutional. And those three provisions were as follows. The first was Section 210, which made it an offense to be an inmate of a body house, to be found in a body house without lawful excuse, or to be an owner of a place who knowingly permits it to be used as a body house. Right? So this body house is a place where you will sell sex. Second was Section 212(1)J, which made it an offense to live on the avails or profit from another's sex work services. And then finally was Section 213(1)C, which made it an offense to communicate or to attempt to communicate with someone in a public place for the purpose of engaging in sex work or hiring a sex worker. So the overall effect of these provisions was to restrict sex work to out-call work, so work where the sex worker has to go to someone else's place, or to restrict it to the street. Okay? So the prostitution reference, as it's known, upheld these provisions. They found that they were consistent with Section 7 of the Charter. And effectively, the applicant made two unsuccessful arguments. The first, they argued that these provisions were in fact too vague to be understood. And it's a principle of fundamental justice that laws must be clear enough that we can know how to follow them. And the Supreme Court of Canada rejected that argument, and probably rightfully so. But the second argument was that the laws indirectly criminalized what was otherwise a lawful activity. So being a sex worker is not illegal. And the Supreme Court also rejected that sort of argument. But the Supreme Court of Canada was able to come to a very different conclusion in 2013 in Canada and Bedford due to the significant evolution of the principles of fundamental justice in the succeeding 23 years. And they utilized over 25,000 pages of evidence submitted by counsel for Ms. Bedford, much of which was not available when the prostitution reference was decided. And the court instead applied these instrumental rationality principles of fundamental justice, and in so doing they struck down each one of these provisions. So with respect to the body house provision, the court found that the purpose of the body house provision was to avoid the nuisance of having sex work occurring in neighborhoods. Okay? So this was found to be grossly disproportionate when compared to the actual effect of the body house provision. So the vast empirical evidence submitted in Bedford proved that sex work in stable indoor locations that you could control was far, far safer than sex work on the street or out-call sex work. As a result, this idea of getting rid of a nuisance, although a legitimate objective for the government, it was effectively resulting in the death of sex workers. So when you compare those two objectives, it's grossly disproportionate. So it violated that third instrumental rationality principle. The second provision, the living off of the avails provision, the purpose of that law was found to protect sex workers from exploitation. So the law was overbroad, though, because it caught not only people that actually exploit people, right? So for instance, a pimp, right, that sells a sex worker, surely that person is exploiting a sex worker. However, that provision also caught other types of workers that might actually protect a sex worker, such as a bodyguard or a driver, someone like this, or a receptionist. They don't exploit the sex worker, but they could serve to protect that person. Right? So if the purpose is provision, or if the purpose of the provision was to prevent the exploitation of sex workers, it caught clear instances where the sex worker wasn't being exploited. Right? So the law was overbroad because of someone like a bodyguard, in fact, wouldn't be exploiting them, they'd be protecting them. And third, the communication in public provision. The purpose of the law was to avoid, again, this nuisance of sex work on the streets. Okay? So the effect of the law, though, was found to be grossly disproportionate as it unnecessarily risked violence against sex workers to avoid this minimally important objective of causing what amounted to a public nuisance. So the social science evidence submitted again established that sex workers frequently could screen for the Robert Pictons of this world, if you will, by communicating with them. So preventing them from communicating with potential clientele took that safeguard away and endangered the lives of sex workers. And again, when you compare the lives of sex workers to trying to get rid of a nuisance, again, when you compare those two things, one is so much more important than the other that it violates the gross disproportionality principle. All right, so since Bedford was passed, or was handed down rather, Parliament passed a new sex work law, which effectively did one major thing. It changed the objective of the sex work laws, right? So it changed the objective from deterring or trying to get rid of a nuisance to trying to deter sex work itself. So arguably this change in objective is weightier, or at least this is what the government's been arguing, than the previous law, which suggests that it will be much more difficult to prove that the effects of the law are in fact grossly disproportionate to its objective. That's what the government argues. They assume that you can, in fact, deter sex work by criminalizing the purchaser, which is an assumption that is going to be tested in trials in the future, whenever this provision is actually challenged. But these provisions, though, are quite complex and require its own sort of lecture to explain any sort of detail. But just briefly, the provisions make it pretty well impossible to have a permanent body house where one hires bodyguards, drivers, and so on. This sort of a body house is allowed if you work there by yourself and you own the place. Right? So those are the two requirements, and I can explain that in more detail during the question period or afterwards if anyone's interested. But so it's not really much different from the previous law. And the new provisions also criminalize, again, the purchaser of sexual services. And as research from both Canada and France have found, prosecuting men who buy sex, this is known as the Nordic model, for those of you who study sex work, or the end-demand approach. This has actually made life worse for sex workers by pushing their trade further into the shadows, making it more difficult to negotiate prices, to negotiate condom use, and making it less likely that the activity would take place where any violent conduct had a reasonable chance of being discovered. So, as far as I'm aware, though, there's yet to be an appellate decision considering the constitutionality of these provisions, but I suspect that they will be challenged using these same instrumental rationality principles in the near future, as soon as the government decides to prosecute one of these cases, and the person has the means by which to challenge the constitutionality of the law. So the second case I want to go through that really illustrates the effect of the instrumental rationality principles is the case of Carter in Canada. So similar to Bedford, there was a previous Supreme Court of Canada precedent where the court found that prohibition on assisted suicide in Section 241B of the Criminal Code was consistent with Section 7 of the Charter. That case is known as Rodriguez in British Columbia, and writing for a narrow 5-4 majority, the court in Rodriguez found that the prohibition against assisted dying was necessary to protect vulnerable people. Okay? And the idea was that if assisted dying was allowed, some people would kill themselves in moments of weakness. Okay? So the need to protect these people, the court reasoned, was pressing enough to conclude that Parliament's law was consistent with Section 7 of the Charter. Now, importance for present purposes, though, is the fact that the principles of overbreadth and gross disproportionality had still not been constitutionalized in 1993 when Rodriguez was decided. So the impetus for the Carter case then was not only this change in constitutional law, but it was also just a general change in maybe the moral understanding of euthanasia. So Gloria Taylor was diagnosed with a fatal neurodegenerative disease known as ALS, which causes progressive muscle weakness. So ALS patients first lose the ability to use their hands and feet, and then the ability to walk, chew, swallow, speak, and eventually to breathe. And like Ms. Rodriguez, before her, Gloria Taylor, did not want to die slowly, piece by piece, or racked with pain, and therefore brought a claim to strike down Section 241B of the Canadian Criminal Code. And what happened, effectively, was that the court applied these new instrumental rationality principles. And in fact, they found that the law was overbroad because it was disconnected from its purpose in readily definable scenarios. So the law's purpose, again, was to protect vulnerable persons from committing suicide in moments of weakness. Right? Yet Ms. Taylor was a perfect example of a person who clearly wanted to avoid this kind of cruel choice of ending her life early while she still had the physical capacity to end her life. And as she was not vulnerable in any sense, the law caught conduct that was disconnected from its objective. So there are also, I made some notes about the new provisions, and they require a bit of a summary. First of all, what the court in Carter determined was in fact the law on euthanasia, on when euthanasia is permissible. So the court in Carter concluded there are 5 requirements. First, that the person must be a competent adult. Second, that they must have, and the language here is important, a grievous and irremediable medical condition. Third, that condition must cause them to undergo intolerable suffering. And fourth, which cannot be alleviated with treatment the patient finds to be acceptable. And then finally, fifth, obviously, the person must consent. Now, the words grievous and irremediable does not, just per the dictionary definition, mean life-threatening. And the court was fairly explicit about that. Yet the new MAID laws, or assisted dying laws, require that natural death is reasonably foreseeable. Right? So this is likely where those provisions are going to be challenged, because the court in Carter was clear that death did not need to be foreseeable. It's a grievous and irremediable medical condition that is required. That's it. So those provisions, those new provisions, are being challenged as we speak in a case called Lamb in Canada, but that case has not been ruled on entirely yet, so we will wait and read when that case finally comes out. So the second major category of fundamental or substantive principles of fundamental justice are principles that I just lumped into this broad category of moral philosophy. So the principles of fundamental justice also protect against state deprivations of life, liberty, and security where a law is inconsistent with a philosophical principle that is central to the way we govern ourselves, particularly in the realm of criminal law. Just for whatever reason, most of these principles tend to be criminal law principles. And we have seen a variety of moral philosophical principles elevated to constitutional status under Section 7, and 3 are of particular importance in the criminal law context, and I'll walk you through each of these to illustrate. So the first set of principles relate to fault requirements, also known as mens rea, for those of you who are lawyers in the room. So the Supreme Court's litigation has constitutionalized 2 elements of fault. Right. The first is a requirement of a minimum level of fault for all criminal cases. So in a decision called the REBC Motor Vehicle Act, the Supreme Court considered the constitutionality of a criminal prohibition for driving without a license. So importantly, the provision required nothing more than proof of the prohibited act itself. So in other words, there was no need to prove that one was in any way at fault for driving without a license. As a result, even if there was a good reason for not knowing that one's license was revoked, such as an administrative error in notifying the person would nevertheless be guilty. And in the particular context of this case, a finding of guilt resulted in a mandatory minimum punishment of 7 days of imprisonment. So the Supreme Court held that offenses with no intent requirement allowed for the conviction of the morally innocent. At a basic level of fault, at least allowing for accused to prove that he or she was duly diligent in attempting to follow the law, was therefore required constitutionally for all criminal offenses. But that very minimal requirement doesn't get us very far. It sets a very low baseline, or a low floor. So the Supreme Court, in a set of other cases, determined that there are also fault requirements, all fault requirements must also be proportionate to the level of moral blameworthiness of the offender. So, although most crimes will readily satisfy this proportionality requirement, the fault requirement for several serious or high stigma offenses, such as murder, have been challenged using the proportionality requirement. And a couple of examples are illustrated. So in a case called the Queen and Valancourt, the Supreme Court concluded that certain crimes attach such a serious stigma that proportionality can only be met with the highest form of fault, which is specific intent to commit the criminal offense. So to better understand this case, though, we need to review two basic elements of criminal law liability. And the first is that there are two types of offenders. They're known as principals and parties. So principals are the person who actually physically commit the act. Right? Parties to an offense include any person who effectively helps the principal offender commit the act. And under the criminal code, there was a doctrine called felony murder. So effectively, if you are a party to certain offenses, among them robbery, and the principal offender commits a murder in the course of that robbery, the party will also be convicted of murder. Right? So this is precisely what happened in the Valancourt case. So the accused and his accomplice had robbed a pool hall, and during the robbery, the accomplice had shot and killed a person and thus was convicted for murder. And the accused, who was the party, was also convicted for murder as a result of this felony murder doctrine. The Supreme Court found that the felony murder provision violated the proportionality principle. And it did so because it substitutes the intent for committing robbery, which is a serious offense to be sure, but it substitutes that intent for the intent of committing murder, which I think we would all agree is a far more serious offense. So the stigma related to the offense of murder and the mandatory minimum penalties applicable made such a substitution inconsistent with the proportionality in fault principle. Now the second area in which the Supreme Court has elevated principles of moral philosophy to the status of constitutional principles is in the context of criminal defenses. And the principle that they elevated is known as moral involuntariness. So before we really get into the criminal defenses, again, as Paul noted at the beginning, I've written quite extensively in this area. But before we get into exactly what the court did here, it's necessary to review basically what criminal defenses are, effectively. So in a case called the Perka and Queen, which was a pre-charter case, the court determined that excuse-based defenses, so there are two categories of defenses, excuses on the one hand and justifications. And they determined that excuse-based offenses connote wrongful conduct that is excused due to the life-threatening external pressure on the accused person's will, in effect. So this principle is known as moral involuntariness, and it requires that the accused must not be criminally sanctioned for giving into a threat if there was no realistic choice but to commit the offense. So the classic scenario of duress is illustrated. Say that someone has a gun and they put it to your head and they say, commit that crime or I will shoot you. You would be under duress. You would be acting in a morally involuntary way for the purposes of the criminal law. So the court in Perka further concluded that the justification-based offense, remember it's the second category of offenses, that justifications connote rightful conduct. So for instance, when one acts in lawful self-defense, the court has concluded that the act is justified in this sense. So whether the principle of moral involuntariness was a principle of fundamental justice was at issue, in this case, the Queen and the Bruges. So in that case, the accused was charged with importing, among other things, importing narcotics into Canada, and she claimed that she was told back in her home of Yugoslavia that she must import the drugs to Canada or her mother would be killed. So given the lawlessness of Yugoslavia in the 1990s, she felt the threat was credible and therefore flew to Canada with 3 kilograms of cocaine on her person. And however, the duress provision in the criminal code limited her defense. It required that the threat be both imminent, which given that the threatener was back in Yugoslavia and she was on a plane to Canada, the threat's not all that imminent, and also that the threatening party be physically present, which again would not be made out on the facts of Bruges. So she challenged the constitutionality of the duress provisions under Section 17 of the Criminal Code. And the court found that the moral involuntariness principle underlying excuses was a principle of fundamental justice, as an act may be morally involuntary despite the threat not being imminent and the threatening party not being present, again as happened in Bruges. The court struck down those parts of the duress provisions of the Criminal Code. And in the end, she was able to plead duress successfully, and she was found not guilty. And I said, I have written quite extensively on the relationship between fundamental justice and criminal defenses. As of today, the Supreme Court has, again, concluded that the law of excuses has been constitutionalized per the Bruges case. But as excuse-based defenses concern those limited circumstances where we excuse wrongful acts, it is almost certain that the law of justification defenses, which again include rightful or at least permissible acts, will also receive constitutional protection under Section 7. So I won't go into that now, but I'm open to addressing that relationship during the question period. Okay. So the last substantive moral philosophical principle of fundamental justice that I want to talk about has to do with youth criminal justice. And it's a principle of fundamental justice that youth are to be presumed to have reduced moral blameworthiness. So in RVDB, the Supreme Court was faced with a challenge to part of its sentencing scheme in the Youth Criminal Justice Act. And Section 2.1 required effectively that courts presumptively sentence young persons as adults for certain serious crimes, such as murder and manslaughter and aggravated sexual assault. So the court concluded that young persons are entitled to this presumption of diminished moral culpability. As the majority wrote, and I'll quote, "Young people have a heightened vulnerability, less maturity, and a reduced capacity for moral judgment." They found that to be supported by the empirical evidence. And as a result, this sort of reverse onus provision was struck down for being inconsistent with the principles of fundamental justice. And the decision more broadly is important, though, because it effectively entrenches a need for youth criminal justice to be a separate system of criminal justice from the adult provisions. All right. And finally, I want to speak a little bit about this kind of thorny issue in constitutional law, which is whether or not a principle of fundamental justice can ever be justified under Section 1 of the Charter. So Section 1 of the Charter allows for the state to offer justificatory reasons for infringing a law. Right? So unlike the American Constitution, where if there is in fact a violation of one of the provisions of their federal constitution, the law is simply struck down, and that's the end of the matter. In Canada, if there's a violation of a right, the state might still offer utilitarian sort of reasons for upholding the law. And laws are justified in this way where they meet three requirements. First, the law has to be rationally connected to whatever objective it has. Second, that law must be minimally impairing of the right in question, which is a fairly flexible test. And third, the law must balance its positive and negative effects in a proportionate manner. If it does so, then that law will be upheld. So, although the Supreme Court of Canada has upheld violations of almost every other rights provision in the Charter, it has never done so with respect to Section 7. Originally, the Supreme Court suggested that the fundamental nature of the principles of fundamental justice meant that they could only be justified in, quote, national emergencies such as war, natural disasters, epidemics, and the like, which is an incredibly high standard for the state to meet. And the court's view has showed some signs of softening in the Bedford case, but the court has still never upheld a violation of Section 7 under Section 1 to this day. But lower courts, however, have really begun trying to test the boundaries of the court's softening of this rule in Bedford. So for those of you who lived in the 90s and followed criminal justice, you may recall a case called the Queen and Davio. Effectively, Mr. Davio had consumed a heck of a lot of alcohol and potentially some drugs, and effectively, as a result of his intoxication, was found to become an automaton. So his activity was considered physically involuntary. He couldn't literally control, from a scientific perspective, couldn't control what he was doing. It's a principle of fundamental justice that that sort of conduct cannot be subject to criminal liability, because you are not acting in any meaningful sense. If there's no act, then one of the fundamental elements of every single crime, the actus reus, is not made out. Now, parliaments didn't particularly like that rule, so they passed a law now in section 33.1 of the Criminal Code, which states that you can only plead self-induced intoxication if the offense that you commit is a property-based offense. So any offense of violence, you cannot plead self-induced intoxication. Now, this provision has been challenged by about a dozen times, and courts are going both ways in determining whether or not such a provision is in fact justifiable. The basic argument is we need to, given that violence it tends to be higher when people are intoxicated, we need to deter that sort of conduct, and by telling people that they can't have this defense when they are violent because of self-induced intoxication, the idea is that that will lessen these types of instances that will happen. So that's the first area where this is being litigated. The second area has to do with respect to the moral involuntariness principle. Now that principle has to do with the two basic defenses, namely duress and necessity. And again, the duress provisions that I explained to you before, those provisions also limit what sorts of offenses you might plead duress to. So there's a list of offenses where the government has said, I don't care if you were acting in a morally involuntary manner, you cannot plead it to these offenses. On that list are things such as robbery and arson, but most importantly for our purposes, murder. So the Supreme Court, a number of appellate courts in Canada have determined that taking those offenses outside of the duress provisions violates the moral involuntariness principle, but they might be upheld under Section 1 because we can't have gangs effectively using this sort of rationale to go around murdering people and getting off later by saying, well, I was forced to commit this crime. Well, who was the threatening party? We don't know who the threatening party is, because you never do in the context of a duress case. Otherwise, that person would be being prosecuted. So those are the two main areas where Section 1 might actually serve to justify Section 7 violations. Other than that, though, I think that's the end of my presentation. I'm happy to take any questions. And also, if you would like to contact me about anything in this presentation or anything Section 7 related, please feel free to email.
I have no legal training, so I'm just interested in this. So,
That's fine.
right at the beginning, you talked about the principles of fundamental justice, and you said that would be a legal principle as opposed to a moral. So, could you give me an example? People who think it's a legal principle,
Yeah.
maybe, but it isn't.
Yeah, so the main example here, as far as I'm aware, the Supreme Court has only found something that is not a legal principle in one instance, and that was with respect to John Stuart Mill's harm principle. So at one point, in a case called Malmolvine, it was argued that the harm principle, which requires that a person, or in order for the government to make an act of crime, the actual act they make a crime must cause harm to others, right? And the Supreme Court of Canada said that that wasn't, in fact, a legal principle. Now, its reasons were threadbare. In fact, it just said, more just declared that it wasn't a legal principle. So the Supreme Court actually hasn't explained that part of the test in any detail. Anyone else?
What do you have two parties that both have rights, and these two rights clash in the middle? How does the court deal with that, or is it a lawyer juggling game to see which one can make the better case?
So, in the context of constitutionalizing principles of fundamental justice, usually what you're looking at is an individual right. When so at the Section 7 stage, we're saying we're looking at the defendant's rights at that stage. We'll consider everyone else's rights or interests when it comes to Section 1 of the Charter. That's usually where that is given force. Now, there are other principles. So, for instance, the right to a fair trial, it's a principle of fundamental justice as well. And it's inherent in the idea of a fair trial that we have to balance interests of the victim on the one hand and the need to prosecute crime, and the individual defendant on the other. So some principles of fundamental justice will just do that within the context of the principle itself, but most of them will, at the right stage, the Section 7 stage, they will say we're only going to look at the individual who has their life, liberty, or security of the person engaged. And then at the Section 1 stage, we'll consider those broader social utilitarian considerations.
Let me mess up there. Isn't thinking more in the moral end of things? For example, with this Bill 207 that's before our legislature now, you've got one group that says, I've got religious rights, I shouldn't have to do it. You've got another group that says, if you don't do it, my rights could be jeopardized and I could have physical harm. How does the court try to balance these two opposing?
Yeah, I'm not an expert on freedom of religion, but again, I think what happens is at the right stage, you ask whether or not this does, in fact, entrench on a right, and then other interests will be considered when we ask whether or not the law is, in fact, a justifiable infringement, right? So a good example in the context of freedom of religion is a case called the Queen and NS, and the issue was whether or not a Muslim woman could wear a niqab while she was on trial, or on the stand. I think she was a witness in that case. And obviously her right to freedom of religion was clearly engaged with wearing a niqab as fundamental to Islamic religion. And on the other hand, though, there was this interest in the fair trial. We like to think that if I can see your face, if I can see your face when I'm cross-examining you, I'm going to be able to tell when you're lying. That's the rationale. And despite there being pretty well known empirical evidence that is true, that is something that the court has accepted. So again, at the right stage, the woman on the stand would be able to say, well, forcing me to take off my niqab violates my rights. But you might also then look at the other side of that, and that's the fair trial interest. So that would be one of those cases where we are in fact looking at those two clashes of rights from the perspective of a fair trial, and you try and just make that work. You find some sort of reasonable compromise, and the courts struggle with it quite greatly.
Who won that one?
Yeah, who won that one?
I think she was the complainant.
And this is a 2009 decision, I think, and I haven't read it in a long time. But as I recall, the court came up with some sort of test for determining when the infringement on the fair trial would be too serious, and therefore the niqab would have to be removed. But in other instances, if the infringement on fair trial rights would be relatively minimal, then the niqab would stay on. They have some sort of basic test.
They basically threw it back to the trial judge and said that the trial judge would have to make a determination in balancing the two interests.
Yeah.
Yeah, I think she was the complainant.
Well, she
Wait,
was.
yeah, pretty sure. So
Oh,
if
she
it's-
was.
I think she was, so that even makes it more interesting.
Yeah. Right. Another question?
You talked about sex workers in the Nordic model, and I was just wondering where Amsterdam fits in with that. I was reading that they're trying to change the laws in Amsterdam right now. And are you familiar?
I'm not an expert in Dutch law, so I can't speak much to that. So.
Okay, well, then I have one more.
Okay, I have questions about that case too.
Okay, yeah, they're just trying to revamp that. They've got a female mayor now who's trying to make it work for everybody. The other question I wanted to ask was, and you touched on it very briefly about structures. And I'm just wondering about people who are living in tents in communities and where their right to live in tents infringes upon the rights of the neighbors, or, how does that work?
So, testing my memory, there was a BC Court of Appeal case maybe 7 or 8 years ago called Victoria City in Adams. And in that case, what had happened is that there was a tent city that was developed in Victoria, and there was some sort of regulation that said you have to tear down the tent city. And they challenged that for violation of Section 7. And they found that that was a state action that was requiring, or that engaged the life interest. And if you don't have overnight shelter, you are exposed to the elements, you may therefore die or become seriously hurt. Therefore, the question was whether or not it was consistent with the principles, or that regulation was consistent with the principles of criminal justice. As I recall, they applied the instrumental rationality principles, right? So I think they applied the gross disproportionality principle. Now, there are about 5 or 6 of these types of cases across the country, so I might be confusing the legal argument in Victoria and Adams in particular, but I know one of those major cases has applied this sort of thinking. Namely that when you're taking down a tent city, what you're saying is you want to get rid of this nuisance that's going on, much like in Bedford. We're trying to get rid of the nuisance of body houses, get rid of the nuisance of communicating in the purpose, or for the purpose of sex work in public. But if the effect of the law is to threaten people's lives, then you can apply a very similar rationale. You're risking lives on one hand to get rid of a nuisance on the other. So it seems like there's a constitutional based on the gross proportionality principle. Now, what the court found, and again, I'm pretty sure this was Victoria and Adams, they found that if there were enough homeless shelters available, then we would have a very different sort of matter. You likely wouldn't have that sort of grossly disproportionate effect. And I think that's what most of these jurisdictions where this has been challenged, what they've done is effectively provide more homeless shelters to just get rid of these types of cases.
So you could still allow people to have their tent, but you get to help them choose the location? If that,
Well, no, like there'd be a physical homeless shelter. If the beds were increased, then at that point you could say no tents, because we aren't causing that grossly disproportionate effect. We are risking your lives because we are giving you a place to stay.
Okay, thank you.
But in the case of no other options, it could be a risk of life.
Yes, exactly. Yeah.
Just a comment. Anna Lund did our previous charter series on the right to housing.
Okay, I guess we must have missed that.
And so you can go to our YouTube channel as well as to our website for her presentation.
And Lund?
Anna Lund,
Yeah, she talks about actually the case that Paul just mentioned as well. And Anna's going to be back actually in January to speak on whether or not the charter applies to corporations.
Oh, that's a good question. Can I ask you 2 quick questions on Bedford, because I find this case fascinating. Living off the avails of prostitution, so if I'm a sex worker, I can't support myself. Because that's, you talk, your case talking about everybody except the person doing the actual work.
So sex work itself is not illegal, so they can live off the avails of sex work. But everyone else can. And then the main idea here is that you wanted to ensure that the pimp was not able to exploit the sex
I
worker.
was wondering if it applied to the actual worker. No, that makes no sense. You can do this job, but you're not allowed to charge money. So my other question is about occupational health and safety. So when I go to work in my office across the street, I have a reasonable chance of not dying today. Right? So are not sex workers entitled to safety? In which case it should be indoors and supervised, and everybody should be safe. But is anyone, you would think that was a reasonable argument, no?
Yeah, and the Supreme Court found that prohibiting sex workers from starting a body house was in fact unconstitutional. And the government came back and has effectively said, you can start a body house, but there's some very complicated restrictions on it, which effectively mean that you can start a body house, first and foremost, if you own the place, actually have title in the land, are in the house, and second, if you, jog my memory, if you don't have others working in it, which again kind of defeats the purpose. So I do think that that body house provision, it's kind of under the new sex work provisions, it's effectively saying that you can't have them make a material benefit from the work of a sex worker. And if you were in a body house, you would be doing that. So although body houses aren't per se illegal under the new provisions, they are active. And that would likely be challenged for the same reason as it was in Bedford. But the question now will be whether or not the effects of prohibiting body houses will be grossly disproportionate. Because remember, the law changed its objective, right? Before it was to get rid of the nuisance. Now they're saying, no, we want to deter sex work. Right? And the government could make the argument that when we deter sex work, we in fact save the lives of sex workers because we get more of them off the street. If our law has its effect, then they can say...
That's assuming they're not choosing this as a profession, which I find...
Yes, exactly. So what's going to happen is that that law's objective is going to be challenged using empirical evidence. And they're likely going to say it has very little deterrent effect on the sex work trade. In fact, all it does is push it to the shadows, making it more dangerous for sex workers to conduct their
And
business.
more of a nuisance to the neighborhood.
Potentially.
I think we better let Colton go because he has a class at 2 o'clock. He's got to do jurisprudence over at the university. So thank you all for coming out. And I would like to say to you that Anna Lund is here in January 22nd, and she will be talking about the chartered corporations. And then Professor Catherine Bell is going to be here in February. And she's going to speak on the duty to consult in Section 35 of the Constitution Act of 1982, which I think is a fascinating and timely topic. And Cameron Jeffries is going to come in March and talk about another very timely topic, the charter and climate change. And he'll be addressing, as many of you know, there's a legal challenge that's going on with 15 young people from across Canada, challenging whether or not there's a charter protection for the adverse health ramifications of the impact of carbon and other waste products in the atmosphere and affecting the health. And so Cameron's going to address that in March, and then Pat Parody is going to come and speak about freedom of expression in April. So there's a number of things coming up. Thank you very much for coming out.